Well, first of all, I'd like to thank, Justice Center, the Law Review, everybody else has made this possible. So good afternoon, Vic Fischer. He needs no introduction, all right? He was there in 1955. I was born in 1955, so we share a lot in common. So it's my pleasure to have an opportunity here to speak to Vic, because really he's one of the few people, as I said, he was there. So this is almost full circle when we talk about the 60th anniversary. We talked about a lot of things, and one of the things we wanted to talk about today was basically the judiciary. My name is Santan. I'm a retired judge. I tell people I retired from full-time work, but I still dabble here and there. The important thing we really want to talk about was the Judicial Council, selection of judges, and the independence of the judiciary. The reason this topic is important is really this. It's been in the news, I would say. It's been flooding the news for the last, how long is it? Month? In fact, it brings to mind, my wife, Errol, shared with me this pie chart that one of our friends sent us, which said, I'm emotionally exhausted. And it says 10% childcare, 5% laundry, 85% Kavanaugh. Okay, so actually I wanted to set the stage by asking Vic, and let's start at the beginning. The Constitutional Convention happened in Fairbanks in November 1955. So tell us your experience of starting there. The gathering, who was there, how it was all happening.
Well, the important thing is the Constitutional Convention took place as part of the statehood movement. It was not just sort of academic exercise or a civic exercise. It was because Congress was considering statehood bills for Alaska as well as Hawaii. But Hawaii had written a constitution in 1950. And in 1954, Congress had not moved ahead on either Alaska or Hawaii to the point of approving statehood for both or one of them. And as Michael just told you, there was a messy previous legislature, and in 1954 there was a heavy reaction to that, and a bunch of fairly progressive pro-statehood people were elected, and in Congress not having acted, they said, let's have a constitutional convention, number one, to be on par with Hawaii, and number two, to show the Congress and the people of America that Alaskans are ready for statehood. And so a convention was called. A bunch of us young people and old, mature people ran for the convention to become delegates. I was not the youngest. I was the third youngest of the convention when talking about Alaska Natives not being included. The concept of writing a constitution was a very ethereal activity. It was, the writing was at the Fairbanks campus of the University of Alaska, which was the only campus at the time. It was in one of the coldest winters Alaska had experienced. It got down to -55 It was below zero most of the time. The convention was away from Fairbanks about 4 miles. We had buses transporting us. There were no bars. There were no restaurant near the university. It was an isolated activity that was very well covered by the news media. Television was just coming. Anyway, I can go into too much detail here, so I'll just say that at the time, when I got to Fairbanks, I knew people from much of the rest of Alaska because I had done work around Alaska, but I did not know all the Fairbanks lawyers who had been elected to the Constitutional Convention. And I met one who had been elected to the first territorial legislature. He was a Speaker of the 1913 House of Representatives, the first territorial legislature, and he was 82 years old. And at 31, I could not imagine how anybody could function at that age. I'm 94 now, and I'm still standing. Anyway.
Yeah.
It was a phenomenal experience. Tom Stewart, I won't repeat what was said by Michael. Tom Stewart did a phenomenal job preparing the groundwork for the convention, organizing things, getting consultants, doing background research, getting materials together, and running the convention. And we had a phenomenal president, Bill Egan. I wrote a book on the Alaska Constitutional Convention. It came out eons ago. But if anybody's interested, I've got a few copies, and they're in the library, probably in the store.
Yeah, I got mine. Amazon, you can still do it, and you can still get it on eBay. I would recommend it to anybody who's interested in what happened. This is really a historical document that Vic wrote. And not only that, he's also a renowned writer. He wrote another book called From Russia with Love. And we're not talking about James Bond here. We're talking about his life experiences. Well, I'd like to move on a little bit because, we're going to talk about Article 4. And we talked a little bit about the Missouri plan, right? And elected judges. How did this Missouri plan come about? Did it come out of a committee? Where was the starting point?
The Missouri plan it came out of committee. The chair of the Judiciary Committee was George McLaughlin, an Anchorage lawyer, a good friend of mine. He and I traveled around our election district, and he knew every bartender on the way to Stewart, and introduced me. But he was very knowledgeable. But at the time we were campaigning, he already knew all about the Missouri plan. He came to the convention ready to work on it, and it was a plan that was supported by the American Bar Association, the Judicature Society, and various other groups. And the Judiciary Committee met with the Alaska Bar Association. There was meeting in Fairbanks during the convention, and they got their act together so quickly that we had a 75-day work session over 90 days, and the judiciary article was the first one that came on the floor before the convention with, I think it was about 1 month and 1 day from the time we convened. Some of the other committees didn't do their final draft until more than 2 months of the convention, especially local government and resources, where a lot of original work had to be done. And I might just mention in that context, we studied the Hawaiian Constitution. We studied the Constitution of most states, and mostly we learned a little bit from other constitutions, but mostly we learned what not to do.
Okay. So from earlier presentations, it looks like elected judges was discussed, but really didn't quite gain any traction. So basically, the Missouri plan was adopted by...
Yes, the Missouri plan was adopted. There was, it was approved initially by a vote of, out of 55 delegates, but probably 53 for, 2 against. When it came up again after further discussion, there was 6 votes against it. But the argument on the opposing side was, as was mentioned, Fairbanks lawyer Bob McNeely argued that having direct election of judges would make the judiciary more responsive to the people, but the majority didn't buy that, and the structure that was built in has worked extremely well.
So I understand that the delegates voted. Some questions are raised whether to have elected judges, and I understand also from reading your book, towards the end of the process, there were some issues raised by a consultant or something like that. I noticed in your book. Maybe you can explain that a little bit more.
Well, the plan that was explained earlier today, where you have 3, the Judicial Council composed of 7 members, 3 appointed by the governor, confirmed by the legislature, 3 nominated, selected by the bar, the State Bar Association, and the Chief Justice ex officio is the chair of the council. That system has worked phenomenally well. There have been attacks on it, but the Judicial Council has been affirmed time and again. There were constitutional amendments to dilute the Bar Association strength, but I thought today's presentation was very, very good. That when the 2 cohorts, the lawyers and the appointees by the governor, when they were together, the Chief Justice went 50-50 on either side. But your question was...
I was directed more in the Constitutional Convention, because right at the end there was a paragraph that I didn't quite understand, because apparently there was some questions raised about the consultants had wrote a memo or something like that.
We had excellent consultants at the Constitutional Convention, and Tom Stewart had found them, and at the end of the convention, there were 3 consultants left, and when our style and drafting committee put all the articles together, and there had to be a lot of work involved in that. I was on that committee. We put in 18, 20-hour days in the last days of the convention, making everything fit, including punctuation and terminology and all. And the 3 remaining consultants read over the whole draft of the final draft of the Constitution, and they came up with a memorandum to the president and the chairs of all the committees, providing a critique, including at on the judiciary article. They said that the Alaska Constitution would provide more control to the lawyers of the state, and not sufficient public control of the Judicial Council. And they came up with a bunch of changes that would have increased the number of, for some reason, to put a Superior Court judge on the Judicial Council, and to provide 1 more governor appointee approved by the legislature. And they also suggested having the Bar Association selections approved by the legislature, which from my standpoint would have politicized the whole process again. But their recommendations came so late in the session, we were ready for adjournment. So the president and the committee chairs just paid no attention to that, and none of their, whatever the other recommendations were, none of them were acted on at all.
So, yeah, so that was very interesting, because it seems like even right towards the end, there's some question about the role of the Judicial Council. You have described about the role of the Judicial Council.
And the Judicial Council, and I'd say the public and the legislature, they've refused to go for changes. We've had several constitutional amendments proposed that would politicize the Judicial Council in various ways, and none of them got out of the legislature. The other thing that I admired with the Judicial Council is that one of our governors refused to accept and appoint one of the 2 recommendations made by the Judicial Council. The council has to provide 2 or more selections, recommendations. The governor said he doesn't like either one, give me more choices. And the Judicial Council said, no, we're following the Constitution. These are the 2 you get, and that's it. And the governor backed down, and that was a very important step.
So the Judicial Council stood its ground, and how many times did that happen? When Do you remember, once or twice?
Twice.
Twice?
Most governors have at one time or another encouraged the Judicial
Encouraged,
Council
okay.
to reconsider, but
Okay.
As Mr. Fischer says, Governor Murkowski
Right.
really challenged, Governor Palin really challenged.
Okay.
There have been a couple of earlier ones that made public their challenges.
Okay.
But as said,
Okay.
the council has always stuck to it.
They always stuck to it. And as Vic has already said, there have been movements, SJR 21, to try and change it in numerous ways, increasing the number, right, from, I think, 6 to 10 or something?
To 10.
6 to 10, and then to have the attorney members also confirmed by the legislature, and to change the quorum requirements and all that, and it failed. And if I understood what you said, you oppose those changes.
Right.
You like the way things are.
And Bud Carpenetti, who was our Chief Justice 10 years ago, he's been very active since retirement, defending the Judicial Council, defending Article 4 against all the attacks that have come from the right.
Well, who knows? We're talking about constitutional amendments. As far as I know, nothing is afoot right now. Am I correct? I've checked and I haven't seen anything out there. Okay, like to shift gears a little bit and talk a little bit. I mean, we don't like, during Constitutional Convention, different methods of selecting judges were examined. Election of judges was basically, shall I say, not voted in, but we have retention elections. So sometimes it gets controversial, as it is today with Judge Corey, who seems to be, shall I say, in the crosshairs of some people. What are your thoughts on retention in election? Is it serving its purpose and affecting the balance that you all thought would happen?
I think the retention elections are very important in terms of giving the public a voice in the functioning judiciary. The Judicial Council does the initial review of qualifications and so on, and there's a very detailed, extensive process, as was discussed, of evaluating the service of each judge and justice and providing that information to the public. And it's worked extremely well. We vote on retention. There's no opposition in terms of another person running for the position. It's an up and down vote. We've had, I would say it's a problem that I think there were times when there were 20 or 30 judges on the ballot for confirmation, and it's sort of exhaustive. And you look at the results, and 1/3 of the people voted no. They just vote no against everybody, but 2/3 vote yes on everybody. And we have this issue right now where there's a fairly organized effort against one judge running for retention. I'd say it's still in balance.
Mm-hmm. I do have a question, if you all know, collective judicial council wisdom. Has a judge that has been recommended for retention by the council ever been voted out?
No.
No, okay, but there have been judges that essentially the council have recommended not to retain. Those have been voted out.
Some of them have.
Some of them have, okay. So on balance, it's a system. As a person who has been in the crosshairs a few times, took a few hits, never went down, okay?
few hits.
A few hits, a few hits. So the judicial retention election. I know I just want to touch base with you on this because I know part of what we talked about this morning was the whole, idea of the initial constitutional convention, where there wasn't a diversity in participation. You have a great memory. You remembered how many people stood for election and all that, and how it came about. I know that you also have you are a great defender of this Constitution as well as a great educator. And you have gone out to speak about this constantly. I mean, you need a speaker. Vic is there, and he speaks to young people, old people, crazy people like myself. He can speak to anybody. But you have actually done a lot of work, right, to bring the Constitution to all Alaskans. Is that?
Yes. Apropos the earlier discussion about Native issues regarding the Constitution, we have the First Alaskans Institute that is an outgrowth of the Alaska Federation of Natives. And it's sort of a research arm and think tank. 10 years ago, on the 50th anniversary of the Constitution and statehood, the president of the First Alaskans organized a tour of rural and urban Alaska to talk about Alaska statehood and Alaska Natives, and it covered the Constitution and becoming a state. And the discussants were basically Lieutenant Governor Byron Malott, who is Native, and Native leader, and
Janie Leask was the president.
Oh, Janie Leask was the president, right, of First Alaskans. Anyway, the panel were Byron Malott and I, and we traveled to Bethel and Barrow and Fairbanks and Juneau and other places talking about these issues. And one of the issues that Willie and Sky discussed earlier today was lack of Native participation, and I made a couple of comments, but there has to be realization that at the time of the Constitutional Convention, the relevance of a constitution was some kind of a pie in the sky, vague thing that had no relation to rural life, to subsistence, to anything. It was a time when fisheries were not at issue. The state was not the territorial government was not controlling fisheries. It was the federal agencies ran Alaska. So it was not a fight against the state. There was at that time, there really was no dearth of fish. The rural subsistence was not particularly regulated. There were issues on migratory birds. Again, there was a national issue. It was not a local issue. There was the state, the territory didn't deal with that. So statehood was very strongly supported in the referendums the referenda that had taken place in Alaska. The votes were consistently for statehood in rural Alaska as well as Anchorage and southeast Alaska and so on. So the convention was not anti-native, but it was not relevant. That is the reason there were not more native, because they did participate in much greater percentage in the territorial legislature, because that was closer to them. Dog control, loose dogs running around, that was an issue in villages, and that was something the territorial legislature preceding the Constitutional Convention was dealing with.
So, were you involved in any of the, I've heard that there were numerous attempts to what I would call the subsistence amendment to be added to the Constitution. Were you involved in that process?
I was involved. My wife, Jane Angry, was very involved. And we worked very hard, and it was a matter of not being, the House of Representatives approved that, the Senate couldn't get it through.
What I understand,
it takes two-thirds of each house to get a constitutional amendment before the public, and the Senate was one vote short. And the issue was that Congress had provided that if the state did not grant a preference right to rural residents in the taking of fish and game, that the federal government would take over management of fish and game in areas where the feds controlled, and the federal government controls 60% of the land area of Alaska. So that includes a hell of a lot of fish and game, and we couldn't get that amendment through. We couldn't get it.
Yeah, failed by one vote is what I remember, what we talked about. So
right. And
it's harder to get a change
right.
constitutional.
And we had a state law providing that preference to rural residents, but our Alaska Supreme Court found that in violation of the Constitution,
right. Which
I didn't agree with them, but they had the last word.
I know we could keep going on forever. I mean, I have probably 1,000 questions I'd like to ask Vic, and we keep going on and on, but I'm always in the interest of time. So I'd like to essentially ask Vic a couple of things. I know we're supposed to talk about, Article 4, the judiciary and all that. You have had now years of hindsight. Based on your observation as the design as well as looking back, what are your thoughts? Is it working? Do we need to tweak it? Any things you'd like to share?
Well, I think the Constitution has worked extremely well in most instances. We just discussed one of the problems that we did run into, but that was a political issue. Sky made a point of the preamble. 10, 15, 20 years ago already, I was asked the question, if you could change the Alaska Constitution, what would you change? And first thing I said was the preamble, that the preamble should have, and it should today, have the respect shown not to the pioneers with the pickaxe and the shoulder and the dog running in front of them, that it should recognize the indigenous cultures that existed for 10,000 years or more before we came and created a constitution. And secondly was we have a marvelous local government article, and it doesn't provide for all sorts of levels of special districts and special taxing jurisdictions. Instead of that, it says taxation can only be at the city and borough. We didn't want counties. We wanted a flexible unit, and boroughs was the majority choice. But there was no provision for tribal councils. At the time of the convention, the word tribal was not mentioned once in the Constitutional Convention. I had worked in rural Alaska, and I had seen a few communities that had Indian Reorganization Act constitutions and so on, but they were not in conflict with anybody. They seemed to be strictly a federal creature and not related to Alaska. So that is another issue that I think needs to be worked. Willie mentioned the unorganized borough, which is a concept that was built into the Constitution, where the idea was that all of Alaska would be divided into regional units based on geography, topography, population, and so on. And the units could become organized and become first class and home rule regions. But all of Alaska would be in organized and unorganized regions where some local planning participation, coordination between state and local and federal activities could take place. The legislature, in setting up the local government structure, provided for organized boroughs and said, and the ones that don't organize on their own become one unorganized borough, which resulted in a borough that goes from the Canadian border all the way to the Bering Sea. Just, it's essentially unorganized, and it doesn't function in any way whatsoever. That is a problem that is going to remain with Alaska until the legislature does something, and that is not about to happen soon.
Okay. Well, all right, we're way over time, so I'm going to wrap up and say...
Wait till you see somebody...
Anybody with any questions?
How do you feel about the next time that it comes on the ballot? Shall we have a constitutional convention?
Well, I may still be around. The next next time is 2022 that we have the decennial question: shall there be a constitutional convention? ? And And the thing about having a constitutional convention is that under the existing constitution, the entire constitution existing constitution can be thrown out and a new constitution written de novo. And some people might like to have a chance to do that. And I would still vote no.
Any further questions? All right. Hearing none, Vic, it's always such a pleasure. It's such a wonderful, wonderful, wonderful opportunity to hear. Mr. Fischer.